Hello.
Yes, hello.
Yeah, hi, hi. Okay, so let me just confirm if all the participants are there and all the judges are there. And do we have a moderator with us from the committee?
I think one of the judges is not available, only us two. Yeah, and I think so. Muhammad Jubail, right? Sorry if I'm pronouncing it incorrectly. Which university do you belong to?
Hello.
I belong
I'm
to
sorry, I'm unable to hear you. I'm just trying to see if it
University
is just
of
on my
Sharjah.
end or
Yeah, I think it's just you because Muhammad could hear me.
is it-
Hi, can you hear me, Aditya?
hello.
Yes, hi, can you hear me?
Yes, yes. Now it's better. I think the settings were an issue. So, do we have a person from the organizers?
I don't. I'm not sure.
All right. So let's just wait for all the judges. Are all the judges here?
No, one of them is missing. There's no. I think it's Aditya.
No, no, no. I'm
Sorry, no,
Aditya.
it's Adiraj Malhotra. Yeah.
All right, all right. So we'll just wait for all the judges to arrive, and I'm not sure if there's gonna be a sort of one of the organizers coming in,
Yeah,
and sort
one
of
second. I just got a message from Leon, right? Yeah. Leon, can you just unmute yourself because it's very hard to see the chat. There's some issue going on.
Hi, sorry. Yeah, Aditya and Ikra. I can confirm again that it will only be the two of you on the bench for this particular round.
Okay.
okay,
Yeah. As far as support goes from Webnyay, if you guys need any help, feel free to shout. I will be over here, and I'll get in touch with one of their representatives to come in if there's anything that needs to be ironed out.
Okay. Okay.
Yeah,
Thank you.
no worries.
okay.
Mohammed, you were saying that you're from University of Sharjah, right?
Yes.
Yes. Okay. So University of Sharjah is present. Is your co-counsel present as well?
Yeah, she's here, Aisha.
Aisha. Okay. Thank you. So, University of.
Yes, ma'am, I'm here.
Okay. Thank you. University of Benin is not here, I think. So we'll just wait for them and then proceed.
Yes, yes.
Hi, Krat. Do we have everybody in the room now? Both the teams?
No, we don't have University of Benin, Nigeria. I think. Yeah.
Just give me a second. I'm just going to check on them. I know they were in one of the earlier rounds, so they're
No,
probably.
this is a separate team.
This is
University of Benin is separate from the University of Nigeria.
no, they were earlier as well. Pre-lunch, they had a session against Hamad bin Khalifa University, University of Benin.
Oh, okay. Okay. Perfect. Okay.
I'm just going to go check in on them.
Okay. Thank you.
And do we have everybody else? I can see we have all the judges.
Yes, we have everybody else and University of Sharjah.
Okay, great.
Hello, everyone. I am the moderator, case manager for this particular round. Who all are we waiting for? Can you specify so that I can reach out and
I think we're waiting from the guys from Benin and also Adiraj or Adrija, the third person to be joining on the panel. I think that much is decided. You mentioned that it'll just be the two of us.
okay, let me reach out. Thank you for your patience.
No worries. No worries. Thank you.
Hi, I believe the University of Benin is also joined. Have everyone from both teams and the judges.
Hi, is the University of Benin present?
Just one of us is here. My co-counsel is yet to join, but she will join shortly.
Okay, so we will wait for everyone to join before we proceed.
Thank you.
Hi everyone. Do you know exactly who has to represent the University of Benin so that I can reach out?
Yes, it's Mocha Fit. She's just having a bit of difficulty joining the meeting, but she's trying to
Should I
rectify it
share the
now.
link? Should I share the link on the chat? Maybe that can be helpful
Um,
if you can forward it.
yes, please.
Yeah,
Yes, please. Thank
I'm
you.
sharing it on chat right away.
Thank you.
We have put the meeting link on chat. Please forward it to whoever has to join the round so that we can get
Yes,
started.
yes, thank you very much for your patience.
Okay, good
Okay,
afternoon,
so
everyone.
yes.
I'm sorry, I'm the second counsel from the defendant. I'm sorry for the late, but I'm here now.
Okay. All the parties are here. Aditya, you're here. Are you still?
Yes,
Yes.
yes.
Okay. Perfect. Okay. So let's begin from the senior claimant, University of Sharjah. Please proceed.
Shall I start?
Yes. Please proceed.
Am I hearable?
Yes, you are.
Okay, I'll start right now. Members of the esteemed tribunal, distinguished advisors, honorable audience, my name is Mohammed Jaber, and along with my co-counsel Aisha Ismail, we are going to represent claimant to fulfill the obligations that falls on Solar Dream upon a contract that was signed between both parties on December 13, 2023. On Wednesday, a quote, on Wednesday, August 28, 1963, thousands traveled to Washington, D.C. by road, rail, and air. There were demonstrators of all races, creeds, and genders, unafraid of the rights of all, known as the Great March on Civil Rights Movement in the United States. Ladies and gentlemen, we gather here as judges, lawyers, and as audience to hear the word of justice and to hear and to gain back rights. A contract was made between a contract was made between two parties in which both they have obligations and rights. When a party does not fulfill the other party's rights, then the contract amount along with the compensation should pop out. Honorable Court, the defense are going to argue upon the tort and the breach of contract. How claimant deserves the contract amount along with the compensation in the incident before your justice. Firstly, going to the relevant facts, we have both two parties, Solar Dream, which is a Canadian space flight, they operate space flights to 10 passengers who are net worth or high net with high net worth. And the second party is Artemis Astrothea, which is a 27 years old YouTuber with a successful channel on yoga and travel. And we have second point, the trip. Solar Dream offers a themed spaceflight treats to do a yoga session on space, which is something new, a new idea, called the Space Yoga Mat, with a part of the floating heaven space. Ticket purchase. Miss Artemis Astrothea, which is a claimant, purchased a ticket from Solar Dream that costs $10 million for a space for her to do a space yoga session on space, uh, and they concluded a contract. Before the quarantine and before the space trip, they have to do a medical evaluation, which is 2 days. They have to do a medical evaluation after purchasing the ticket and after paying the amount of the ticket. She did a medical evaluation before the preparation of the trip. Then there was a quarantine that lasts for 2 weeks for the training purposes, in which they are going to a place where there is no gravity there. That's why they need a training. And this is a point where there should be a quarantine, and she was under quarantine. Then suddenly, during the quarantine, there was a disease similar to COVID-19, which is the volcan, which is a disease which is spread fast, and it's similar to COVID-19 as mentioned previously. Before the trip and after quarantine, she had, it was not mandatory, but the space flight operator forced each passenger to do the PCR test. So we have 9 results out, which was negative. The space captain did not wait for the last result and launched the space. And suddenly, when he knew that there was a positive PCR test, he came back. The captain of the trip put an order to come back to Earth without ending the space trip, which costs $10 million for each passenger. So you're talking of $100 million. So here, when Miss Artemis Astrothea came back to Earth, she searched about a court of space and found it in the DIFC, and she took a legal action to raise a dispute on Solar Dream. So here we have the issues. On behalf of claimant, respondent is liable in tort to argue the fact that respondent affect the reputation of claimant as an influencer who has 20 millions of subscribers and a content creator who promised her followers to have a record yoga session in space, despite the fact the trip did not success. However, the non-success of this trip resulted the effect of claimant source of income. In origin, the parties shall comply with the terms of the agreement signed by both. Nevertheless, respondent breached his obligations as an organizer of the trip, while the terms in the agreement does not contain any ambiguity or confusion, resulting of claimant paying millions of dollars without receiving any service. For moving to the agreement, does the tribunal have any question before going to the moving to the arguments?
No, no, you can proceed. Unless,
No, no,
yeah.
none from my side either. Please proceed.
Thank you.
Could you please help me to with the pronunciation of your name, Ikra? If
Yeah,
I'm
Ikra Islam.
impressed. Got it. Thank you.
Sorry, I couldn't hear.
Please continue. Please continue, Moot.
Thank you. On the argue of tort, if I may lead the tribunal to page 9 of the case, paragraph 19, my mistake. We can see that tort law is the law of obligation number 5 of 2005 of the IFC. The law did not give an explicit definition on tort. However, it was defined under laws as any physical damage, personal injury, or economic loss. So one should be satisfied to establish tort. Under DIFC law obligations to establish the liability in tort, Ms. Astrothea would need to show and upon Article 17.1, first point, Solar Dream owed duty be under an obligation of her duty of care. Solar Dream, as a spaceflight operator, owed her a duty of care as a passenger to ensure her reasonable safety. This likely included proper protocols to screen passengers for infectious diseases that could harm other passengers. If I may lead the tribunal to page 5 of the contract, Article 7. Spaceflight operator should deem all actions to ensure the safety of the passengers. Upon the agreement between both parties, claimant shall be quarantined 2 weeks before the trip for the purpose of training, since they are going to a place where no gravity there. However, there were medical evaluations held before the quarantine of to all passengers by the operator. According to page 4 of the contract, Article 5. On the other hand, claimant and before the trip was asked to do a PCR test, which was not mandatory, and it was positive. Then she were affected with the disease during the quarantine, which her safety during that period was an obligation on defendant, which is Solar Dream. This results, and under the contract agreed between both parties, and defendant deems duty of care to claimant. Esteemed Tribunal, if I may lead you to be Article 18.1 of Law of Obligations, with relying to the mentioned article, we have a case that was decided by DIFC courts in 2020. It's a huge case between Punjab National Bank, DFC branch, NMC Healthcare, New Medical Center Trading, NMC Specialty Hospitality, NMC Specialty Hospital, which it was in general between Punjab National Bank and NMC Group, which is a huge group. A judgment took place in both cases that respondent should deem all duty of care to claimant upon an agreement between both parties. In the event any irrelevant circumstances occurs other than the force majeure, defendant is liable to compensate claimant. Moving to the second point, esteemed tribunal, you might say that she did not declare her chronic symptoms. To answer this question, we have two decided cases in the USA, which held or was decided as the following. The first case is Loyler versus Comprehensive Health Services, and the second case is the United States is the Watkins versus CHS Middle East LLC. And the above two cases are related to the question of the tribunal and the claim of defendant, in which claimant did not declare all medical records. It was held that in the event the parties does not have a stamped document from a certified doctor, then it's not appear on her to prove that she had any symptom. In addition, we have two cases that was decided in India in 1995 and 1996, which was the parties Puno Medical Foundation versus Marutwana Tikare and Miss Rahaji versus the Mahartansa Medical Council. I apologize if the parties I announced them wrong, but since it is somehow hard and it's not my main language, so it was held that it is on the peer of the hospital or medical service center to do a clear medical checkup if needed. Upon a medical article that
Counsel, I have a question. How is the cases from US and India applicable to the DIFC courts?
Madam Judge, the rules of the case was clear. We can get any decided cases from the DIFC, all the previous, but the DIFC does not have any decided cases related to medical records. So they told us to get any decided cases from the common law system. US and India is considered one of the pioneers in the common law system.
Okay, thank you.
Did I satisfy your question?
Yes, it did.
May I proceed?
Yes.
Thank you. Plus, in addition, upon a medical article that was released in 2001 under the title of Evaluation of Headaches in the Adults, It was resulted that the general physical examination should include vital signs, fundoscopic and cardiovascular assessment, and palpation of the head and face. And this should be clear to a medical evaluation made by defendant, which was their obligations, was not well measured. Does the tribunal have any question before proceeding to the second point?
No, so two questions here. Now,
Please.
first question that I want to ask you is what percentage would be sought in tort, and what percentage, the exact amount which would be sought as the damages for breach? And the second question that I have for you is, are you saying that the declaration, the non-declaration by the claimant has got anything to do with the test results?
To address your first question, Mr. President, the claims and damages is considered $15 million, $10 million for the service which she paid, which is the ticket price, and $5 million, which is considered a compensation because her economic or her source of income was lost. She uh, she is a content creator, as mentioned, with millions of followers. Now the millions of followers who are following her does not trust her,
But
so her source of
I'm
income
just
is
trying to wrap my head around this. Uh, how does the loss of income even come into picture? Because this is far too remote and indirect sort of consequence for a commercial company to be even concerned with.
when a commercial company does not provide the service which there was a contract between both parties, then this commercial company shall compensate according to Article 17.3 of the IFC Obligations Law.
You know, I'm strictly talking about the loss of revenue,
Loss of revenue for whom?
a loss of revenue to the claimant, loss of income, sorry, loss of income. Why does Solar Dream have the obligation to compensate Artemis for loss of income?
As mentioned previously, Mr. Judge, in Article 17.3, there are three situations. One should be satisfied, either bodily injury or either bodily injury or either physical damage or personal injury or economic loss. This is upon Article 17 of the IFC Obligations Law. So here we have economic loss.
Yeah, but I believe, okay. So when we're talking about loss of income, what we're saying is that, and correct me if I'm wrong, that she would have she would have taken the flight. She would have taken certain videos during that flight, which she would have posted on YouTube. And basis the subscribers and the views, she would have generated certain income had everything gone the way it was originally envisioned in her head. Correct?
Before, after she purchased the ticket and before the flight operated, she promised her followers. She promised them that she is going to record a yoga session on space.
So the 5 million is essentially attributable to the income which would have been generated had the flight gone the way it was originally envisioned and her videos coming through.
Mr. Judge, it should be more than $5 million, but Miss Artemis Astrathia, she estimated it as a $5 million compensation.
No, so
But
my question to you here is exactly this Solar Dream, which is just providing a tourism flight. Why does Solar Dream have to be concerned with any potential income which Artemis may be earning by posting videos and so on and so forth? I mean, it's a simple tourism related arrangement. It's a contract, and I'm just trying to connect the dots, because for me the claiming loss of income is too indirect, and I do not see how the obligation is falling on Solar Dream to compensate for that, unless of course you can point me to the contractual terms, or you can point me to if you're claiming it in tort, then the relevant law through which you can establish a link.
There is nothing related in the case that mentions the economic loss, but however, we have the law itself, and we are obligated by the law. So we have the law. If there is an economic loss for any of the parties, and Miss Artemis Astrothea is considered a content creator, this is her only job. So if it was affected, then she is on economic loss. However, if I understand your point, Mr. President. Your point is as following: if we have two different companies, then there is an economic loss. Here we treat Miss Artemis Astrothea as a company. Since she's a
No,
party
no, no,
against.
that was not my point. That was not my point. My point being is, how is Solar Dream concerned about any loss of revenue?
How is what? I
Solar
couldn't hear.
Dream concerned about any loss of revenue?
How is Solar Dream was what?
Concerned about any loss of income for Artemis, or be it a company in its place? How is Solar Dream considered at all with respect to any lost income, unless there is a sort of a causal link which you can draw, unless it is not remote, unless you can show me that Solar Dream for some reason had an obligation to ensure that the loss of revenue or loss of income of Artemis would be covered.
Sir, the fail of the trip is enough to conclude that that there is no service provided first. Second, that the source of income was affected of Miss Artemis Astrothea, since, as mentioned in the case itself, and on the relevant facts, that she's a YouTube content creator, and this is her job.
Okay, you can proceed.
Thank you. Moving to the second point, Solar Dream breached that duty. How?
Sorry, Council, can you please conclude your submissions in a minute or two because your time is up?
Okay, Miss Judge. Solar Dream breached this duty by allowing her to fly without receiving the PCR test, which they did not check. And we have a similar case, which is the delocked versus the KLM Royal, in which they did not check the PCR test of in the flight of one of the passengers, and now the delocked, which is claimant, he got compensated because his children were affected by COVID-19. In this, I finish the argument of tort, and I leave the floor to my co-counsel Aisha to argue breach of contract. Thank you.
Thank you, Council. We may proceed with the senior defendant.
Very well. Thank you. Thank you, members of the bench. Good morning, Your Honors. Good morning, members of the bench. My name is Ms. Kate Moka, and I'm the Senior Defendant's Counsel representing Solar Dream in the suit at hand. And with me is my core counsel in the person of Ms. Ade Akimbami, who would be representing as the Junior Defendant's Counsel at the case at hand. Your Honor, we have a total of 45 minutes, and we have decided to keep 20 minutes for the senior defendant's argument, 15 minutes for the junior defendant's argument, and reserve the last 10 minutes for rebuttals, 5 minutes each. May I proceed to give the short summary of the case at hand?
No, there's no need of that. Please move to your submissions.
Very well, Your Honor. Your Honor, I firmly have come to contend with the claim of the claimant that the defendant, Solar Dream Incorporated, is responsible, liable for negligence and a breach of contract. Your Honor, the position of the law is that parties are bound by the terms of their contract, and this is a tried submission that has been established in several cases, including the common law locus classical of the case of Silk and Marrick.
But Faith,
Your Honor,
Faith, I do not think it is the case of the respondent that either of the parties are not bound by the contract.
very well, Your Honor, I totally agree with that. It's just a premise for me to base my submissions.
Okay, please proceed.
Thank you, Your Honor. Your Honor, Well, this is the position of the law, and so in this case, the parties have to be bound by the terms of the agreement. Your Honor, the space flight travel is one that has series of risks involved, and this was well informed and told to the claimant, specifically in clause 4.1 of the contractual agreement between parties, which was signed by both the defendant and the claimant. Your Honor, in this case, one of the basic risks that was involved is the closing of the windows and the launching of the flight before the proposed time due to meteorological conditions, Your Honor. Your Honor, this has been specifically stated and made space for in clause 4.1 of the agreement, where some of the risks was listed, Your Honor. Your
Could you please
Honor,
repeat the clause
the
number?
Your Honor,
Could you please repeat the clause number?
very well, Your Honor. Let me read it out.
Pardon?
Your Honor, clause 4.1 of the contractual agreement 4.1 first says that the passengers acknowledges and accepts that the space travels involves inherent risk, uncertainties, and possibilities of unforeseen events. The passenger is aware that despite the spaceflight operator's best efforts, certain risks may be unavoidable.
But I do not think this is a risk associated with space travel. I think it is a risk associated with how sternly your protocols and how accurately your protocols deal with it. And now, if I were to look at at the facts before us, I see that only a test was done whose certainty cannot be assured. There are cases when after this test is done, tests have come out negative falsely. On top of that, while you were sort of in your process of launching this flight, you have taken an advice of a nurse. Uh, I'm not sure, and you yourself have given a go ahead. Uh, Even though, I mean, this is just a matter of convenience. You say meteorological conditions, but however, all of those conditions would have, at the worst case, only delayed your space flight. So it was a commercial decision. It wasn't that you were forced to launch the flight with the less proper security protocols.
Okay, thank you, Your Honor. Your Honor, I would now seek to bring to the notice of the court that the advice of the nurse was not one that was just given based on without a foundation and without a solid foundation. Your Honor, the advice of the nurse telling the space flight to launch was because series of tests had been conducted. Examination had been conducted by a retired NASA doctor, as well as other physical examinations. Furthermore, Your Honor, a lateral flow test had been conducted, and for each of these examinations and tests, the results were out, except the PCR test. Your Honor, the advice of the nurse was not based on ignorance, rather, she had looked at the current circumstances at hand and had seen that from the results of the examinations gotten and from the results of the lateral flow gotten, that to a large extent all passengers
What
were
I do
safe.
not understand is, see, it's a simple thing. You're sending a bunch of
Your Honor, I don't know if I'm having, sorry, Your Honor, I don't know if I'm having technical issues, but I'm finding it very difficult to hear you well.
Okay, am I audible now? Can you hear me?
Yes, I think I can hear you better now,
Okay,
Your Honor.
so I'll just clarify what it reads is one, you're a company who's for millions of dollars selling tickets to individuals who are affording those tickets. And when it came to the security protocol, from what I can see, you have cut corners, right? Because Solar Dream personnel decided to give a green light for takeoff, and the only justification which is given for that is the advice of the nurse on duty was that lateral flow test was sufficient statistically to rule out any serious risk. What about risk otherwise? If it is a space flight, you should be doing your risk management very thoroughly. So
Okay,
is it
very
not a
well,
fault
Your
on your
Honor.
part?
Thank you, Your Honor. Your Honor, it is still a firm submission that they were not negligent in picking or launching the space flight. This was due to the fact that as at the time when the space flight was launched, due to the circumstances at hand and due to the meteorological conditions at hand, it was necessary that they launched at that particular time, Your Honor. Your Honor, if they had not launched at that particular time, it cannot be sure or be assured that they would have been able to take the flight as the meteorological conditions are not within their control, Your Honor. And so that was one of the unique risks involved to ensure and to allow. Oh,
I think we've lost you, Faith.
Your Honor, can you hear me now?
Yes, yes,
Okay. Please, can you see me as well?
yes, yes.
Okay, thank you, Your Honor. Your Honor, it's still our firm contention that the meteorological weather conditions are not one that are within the control of the defendants. This is one of the risks involved in the spaceflight travel, and the claimant was very well informed of this risk. And this is under the principle of law of voluntary non-fit injury, which says that to a willing person, it is not wrong. In other words, once a person has agreed to a contract, to the benefit of a contract, it is assumed that he has also agreed to any inherent risks that comes as a result of fulfilling such contractual obligations. And this is what clearly applies to the case, to the fact at hand, Your Honor. Your Honor, may I proceed? Are you satisfied?
Yes, please.
Thank you, Your Honor.
Unless
Your Honor,
unless Ikra has any questions.
Not at the moment.
thank you very well, Your Honor. Your Honor, the second submission on which I base my ground that the defendant is not liable for negligence is on the principle of exclusion of liabilities. Your Honor, the position of the law as regards to exclusion of liabilities is that once parties have agreed to certain terms of the contract, which includes exclusion liabilities, then they are bound by those terms of the contract and cannot resile it. Your Honor, this has been given the judicial backing in the case of Lestrange versus F. Graco, where the court firmly held that once parties have agreed to certain terms of the contract, they cannot on any ground resile it. Your Honor, if you go to clause 4.5 of the agreement, it was clearly stated that the defendant would not be liable for any loss or for any injury in any case, except it is proven that gross negligence was engaged, which is not the case at hand, Your Honor. Your Honor, in that
But
same clause,
I'll just stop you over there, Faith. Could you please tell me how it was not gross negligence and also how it was not willful misconduct?
very well, Your Honor. Your Honor, the defendant had carried out series of examinations, series of tests. The examinations carried out, Your Honor, were not carried out by unprofessionals, neither were they carried out by people who were not experts or had not been practicing. From the clarification of the Moot fact sent to us, it was said that one of the examiners had been practicing for over 10 years, particularly the nurse. And the first examiner, who was the retired NASA doctor, had been practicing for a very long time, Your Honor. Your Honor, they had done due negligence in employing these people to work with the space flight in order to examine each of these passengers, Your Honor. They had done a thorough examination. They had as well conducted two tests, which was the lateral flow test and the PCR test. However, due to reasons beyond their control, which is the meteorological conditions in the facts of this case, they had to launch before the PCR test was brought out. It is therefore not negligence, Your Honor, as they had
Oh,
followed.
counsel, apologies, I'm cutting you, but I just wanted to clarify your clarification on this. Relying on LFT test without waiting for the PCR test is not negligence. That's what you're saying. That's your stand.
Your Honor, my stand is this. Um, they didn't fail to wait. It wasn't a scenario or a circumstance where they refused to wait for the PCR test. Rather, it was a scenario where they had to go due to reasons beyond their control, Your Honor. Your Honor, the meteorological conditions are things they can't control. They are things they are subject to. It's one of the risks involved in space flight travel, as
No,
seen
but
in
Faith, answer me this. Was it more commercially feasible to launch the spacecraft because of the meteorological conditions, or was it that you had to launch it?
Very well, Your Honor, we had to launch it. It wasn't a situation beyond the control, as the space flight does not control meteorological conditions or weather conditions. Your Honor, are you clear? May I proceed?
Yes, proceed.
Thank you so much, Your Honor. Your Honor, this is the position of the law that once parties are have signed particular terms of the contract, and which includes exclusion liability as seen in the case of Lestrange vs. F. Graco, then they are bound by the terms of that contract. Having been a party, having the claimant being a party and his signature to that contract, she is bound by that exclusion laws. Your Honor, I may further want to bring to the notice of the court that that same paragraph 4.5 of the clause firmly states that in any case, the liability of the defendant would not be more than $1 million. However, Your Honor, the claimant has come
Faith, we have lost you.
Yes, Your Honor, I'll try to get her back on the call if you just permit me a few minutes.
Can you hear me?
Yes.
Yes.
Thank
Thank you.
you, sister.
This is
Thank you.
therefore my submission on the first ground, Your Honor. Your Honor, on the second ground, will firmly submit that the defendant is not liable for a breach of contract. I want to confirm that I'm still being heard. My screen is blank.
We
We
can
can
hear
hear
you.
you and
We can
see
hear
you.
you and we can see you clearly. Please continue.
Your Honors, please confirm that you can hear me.
Faith, can you please log out from one of the devices because it's going to echo?
Yes, I think that's
Yes,
done.
I seem to
Please
be.
continue.
I'm being logged out of the other one already. I guess I'll just use this device proceeding forward.
Yes.
Please
Okay,
proceed.
please
Thank
proceed.
you, Your Honor. Your Honor, it is therefore my firm submission that the defendant is not liable for a breach of contract. Your Honor, this submission is covered by the legal principle of the doctrine of necessity, as well as the principle of the doctrine of first major. Your Honor, the doctrine of necessity is a legal principle that establishes that when there is a contractual obligation that cannot be fulfilled due to public interest or for public safety, then failure to fulfill that contractual obligation will not amount to a breach of contract. Your Honor, this has been established by the common law case of Mout, where the Mouse case established by the King's Bench Court, where the captain of the ship had to throw away some of the cargo of the passengers as the ship was sinking. The passengers then sued for a breach of contract, and the court held that the act or the action of the captain of the ship was for the protection of public interest due to the circumstances of the case, and as well as to safeguard and protect lives. Your Honor, in this case, failing to allow Miss Artemis to participate in the yoga retreat was simply a necessary action taken by the defendant for public interest and for public safety. Your Honor, Miss Artemis, it was confirmed that she had the COVID-19 variant, which was a deadly variant and very easily contractable. And so the defendant had the duty to ensure that to the best of their ability, they protect the public and the interest of every other person on board. So her being quarantined and prevented from participating in the yoga retreat alongside other members was to prevent the outbreak of this disease. However, Your Honor, despite the proactive actions of the defendant, it was clearly stated in paragraph 11 of the case fact that the flight, sorry, paragraph 13 of the case fact, that the flight had to return unduly, and this was due to the fact that they had started noticing symptoms in other passengers. This was clearly an act that was proactive and necessary on the part of the defendant. It is based on this submission, this principle of law, and this doctrine that I hereby establish my firm submission that the actions of the defendant was necessary and covered by the law, and so they are not liable for a breach of contract in the case at hand. Thank you,
But
Your Honor. I'm
I
open
believe
to
I just have a
questions.
question in that regard, provided. Okay, so that it is not the case that you getting them back was a breach of contract. I think that never was the case. The case is that you breached contract by breaching some of your very important obligations under it, that is to maintain and implement certain safety protocols properly. Now, you could have maintained those protocols, but you compromised on those protocols to launch the spacecraft early, because the meteorological conditions would not have allowed you to launch it in the right window, thereby potentially causing you certain economic loss. So it was a commercial decision that you took to uh, let go of certain safety protocols and launch the flight at the risk of safety of its passengers, and for some reason it backfired, and as a result of which we are here with the other side trying to decide on damages.
Okay,
Tell me, what are your thoughts about this? Am I wrong? How would you rebut that?
okay. Your Honor, I respectfully disagree that the defendant ignored and became negligent of certain safety protocols. Your Honor, I seek to bring to the notice of the court the locus classical case, common law case for negligence, which is the case of Donogo and Stevenson. And this has been established in several other cases, both under the common law jurisdiction. Your Honor, the standard of care is the standard of a reasonable man, Your Honor. In other words, what would an average man do in this situation? Your Honor, the position of the law, also in Aries case, Aries Resources case versus Union Bank, which is a DIFC court case, the court held, um, am I still being heard, Your Honor?
Yes, yes.
Okay. The court held that a party does not have to be put under extreme or undue hardship just to protect the person. Rather, it is an objective, Your Honor, an objective standard of care. In other words, what would a reasonable man do in this condition? Your Honor, it is on that ground that I stand to say that the actions of the defendant in this case past this objective, the standard objective of care, the standard of care, which is an objective care. In other words, what a reasonable man would do. Your Honor, the other test results had come out, the examinations had come out, the examinations was successful, and so it was then established that we exercised a reasonable standard of care. Furthermore, Your Honor, I would also want to bring to your notice that Ms. Artemis failed woefully in fulfilling her contractual obligations by not declaring the headache. Your Honor, specifically in paragraph 8 of the Moot problem, it was clearly stated that she failed to declare this because she was scared that they wouldn't allow her to participate. Your Honor, in a circumstance or a scenario where she had declared her medical condition, then we can now infer that the defendant had the obligation to go beyond the regular standard of care and to ensure that all of those results, including Prisha, are brought out since there was a peculiar circumstance. However, they were not informed that there was a peculiar circumstance making reference to Miss Atami's chronic headache. And so they carried out the objective standard of care that an average man would carry out, Your Honor.
Okay, thank you, Faith. Ikra, I just want to check with you. Is it not the case that their time has run out?
Yes, it has.
Okay. I think Faith, kindly conclude in a few sentences.
Thank you, Your Honor. Your Honor, this is therefore my submission that they are not liable. I've successfully been able to list out my submissions and the points on which I base my grounds. And I pray that this honorable court hold that the defendant is not liable for negligence and not liable for a breach of contract. These are my prayers. Thank you, Your Honor.
Thank you. We will just move to rebuttals now. And since you have taken more time, uh, we will actually cut down your time on the rebuttals. Is that fine, Faith? Okay. So
Very well, Your Honor.
let's move to Mohammed Jabil. Yeah, the senior claimant. Please go ahead with your rebuttal.
Mohammed, we are unable to hear you.
No,
Yes, we can hear you now. Your camera
uh,
is still, we can't see.
just 1 minute.
Yes. Yeah,
Can you hear me now?
yes.
Uh, Now for the rebuttal, according to an article of a doctor in 2001 that was released, since she did not declare her chronic disease, it should be followed and should be clear on the medical evaluation. So, what is the response of respondent on this claim?
Okay, thank you. Can we move to the sub rebuttal by the senior defendant?
Very well, Your Honor. Your Honor, my submission is that the acts of the defendant, my share about us, these are the acts of the defendant was not a breach of contract and that her declaration, a failure to declare, was a breach of contractual obligations on her part. Your Honor, if I may point you to paragraph 8.3 of the contract signed between them, it was clearly stated that she had an obligation, Your Honor, to declare all medical conditions. And failure to carry out that obligation is a breach, as seen in the DIFC law of obligation. This is therefore my submission to Your Honor. Thank you.
Okay, thank you. Uh, is there any questions on your part, Aditya? Should we
No.
proceed to the junior councils? Okay, so let's proceed to the junior councils. Let's start with junior defendant.
Thank you very much, Your Honor. May it please this court, I appear before this honorable court is A. Ade Akimbami, the junior counsel for the defendant. And Your Honor, I'll be addressing this court on the counterclaim which was filed by the defendant counsel. And this counterclaim is premised on the fact that Ms. Artemis Asprethia is liable for a breach of contract. And Your Honor, on this particular counterclaim, we have two major standpoints. One being that Ms. Artemis Asprethia failed to declare a medical condition as agreed by the parties under the contract. And our second standpoint is that Ms. Astrothea Artemis also failed to make a final installment payment as agreed by the parties under the contract. Your Honors, if it pleases this court, I seek the leave to delve into the substantive parts of this argument.
Proceed.
Thank you very much, Your Honor. Your Honor, on the first standpoint of this counterclaim, which is that Ms. Artemis failed to declare a medical condition as agreed by the parties, the position of the law by virtue of Article 10 of the DIFC Contract Law 2004 states that or provides that a contract validly entered into is binding upon the parties in that particular contract. In essence, what this means is that once parties consent to enter into a contractual relationship, then they are bound by the terms of this agreement. And this is in line with the fundamental principle of law, acta sunt servanda, which means an agreement must be kept. Your Honor, moving on by virtue of Article 56 of the DIFC Contract Law 2004, which is applicable before this court, it provides that the terms of a contract may be either express or implied. And basically, in essence, the express terms of a contract are the terms that have been expressly stated or explicitly stated, directly stated in the contractual agreement. And this means that the parties are hereby bound by the terms contained in that particular agreement. Your Honor, in application to this particular case before this honorable court, if you look at paragraph 7 of the moot problem, which is before this court, where it was stated that on the 10th day of December, after Ms. Artemis had extensively spoken to a sales representative from the defendant company, she had read and signed the agreement, hereby agreeing to all the terms in the contractual agreement and giving her signature to it. That means that she had consented to be bound by the terms of that agreement. And the position of the law follows that once a party agrees to be bound by, voluntarily agrees to be bound by the terms of an agreement, then they must fulfill or they must follow that contractual obligation. And this was given judicial backing in the common law case of McDonald versus John, a case which happened in the year 1953. And Your Honor, it is based on that we say that Ms. Artemis had breached her contractual obligations by failing to provide or failing to declare a medical condition. Your Honor, moving on, if we take a careful or a surface perusal at the eighth paragraph of the moot problem,
I'll just have to interrupt here. Your claim
yes, Your
is
Honor.
for 5 million USD, and you're saying that your claim is resulting from the non-declaration and therefore a breach by Artemis of your contractual terms. Is that correct?
Yes, Your Honor, that's correct.
Now tell me why, how does what does the non-declaration have anything to do with the damages that you're claiming?
Well, Your Honor, by virtue of Miss Artemis failing to declare her medical condition, firstly, it led to the fact that other passengers, after the space flight had ended or after the journey had ended, landing back on Earth, then Miss Artemis published a YouTube video telling people that Solar Dream Incorporated was not competent enough to carry out their activities, and this particular act led to substantial losses on the part of Solar Dream, being that
So
other
what did
participants.
after landing back, what did Artemis say? That I did not declare my medical conditions, and they could, like,
No, not
how does that? I'm just trying to figure out causation because I don't see how that is in any way related to the claim for damages.
Your Honor, by virtue of the fact that Miss Artemis failed to declare her medical condition, and thereby the fact that during the space flight trip, other passengers were other passengers got sick or got contracted COVID, and then after landing, she had released YouTube videos explaining that or
No, no, no.
saying
So
that.
my question to you is this: did her non-declaration have anything to do with COVID?
Sorry, Your Honor, may you come again?
Did her non-declaration have anything to do with COVID?
Her non-declaration. Your Honor, her non-declaration doesn't exactly have anything to do with COVID, based on the fact that she was not aware of the fact that she had COVID, Your Honor.
No, because from what I can see is that she was getting chronic illnesses for the past, chronic headaches for the past 5 years. So I mean that the disclosure or non-disclosure thereof, how does that impact the damages that you're claiming in the COVID and the entire fiasco which happened?
Your Honor, our position or our submission is based on the fact that since Miss Artemis failed to declare her medical condition, this then led to a breakout of COVID on the space flight trip. And by virtue of that, other passengers or other potential passengers, potential customers, thereby cancelled their request or their indication to be passengers in subsequent space flight trips. And this amounted to substantial loss in the form of money to Solar Dream Corporation, being the defendant in this particular case, Your Honor.
Okay, proceed.
Thank you very much, Your Honor. Your Honor, as I was earlier stating, if you look at paragraph 7 of the moot problem, which is before this honorable court, so that Ms. Artemis was also given a medical logbook in line with the contractual obligations, particularly the fifth clause of the agreement, where it provides for a series of medical evaluation and a series of medical tests or medical information that every passenger is to declare. However, Ms. Artemis also failed to state the headache that she had been suffering from for over 5 years, and then this particular failure to state the information of her suffering from over 5 years led or amounts to a breach of the contractual obligation, being that every passenger is supposed to state any medical condition, any medical ailment that they were suffering from, had previously suffered from, or any symptom of a potential medical condition, Your Honor. Your Honor, it is on this ground that we submit that Ms. Artemis Astrothea is liable for a breach of contract. And then this now moves me to my second standpoint, which
Just,
is that
just,
Ms.
just
Artemis.
one question
Yes,
for
Your Honor.
you. Can you tell me that had Artemis disclosed that she had chronic headaches going back 5 years, if this disclosure were made, would you have been able to, in any manner, prevent what happened?
Yes, Your Honor, definitely, Your Honor.
And then
Assuming
please answer how.
Yes, Your Honor. Assuming Ms. Artemis had declared this medical condition, then the circumstances to which Solar Dream would have carried out their evaluation, their medical evaluation, would have been in a better position to prevent any foreseeable harm. However, not having in mind that Ms. Artemis was suffering from headache, they were unaware of any potential threat to which they could not prevent at that particular time.
Okay, proceed, sir. Proceed.
Thank you very much, Your Honor. Your Honor, on the second standpoint, which is that Ms. Artemis also failed to make a final installment payment, the position of the law, as earlier stated by, in the case of McDonald and John, that once parties agree to enter into a contractual relationship voluntarily, then they are bound by the terms of that agreement. And the second clause of the agreement, which is before this honorable court, particularly the second clause, particularly the second paragraph, provides for the modes of instrumental payments spanning over 4 installments, to which every passenger, including Ms. Artemis, is to remit a sum of money to Solar Dream Incorporation. And Your Honor, the last instrumental payment was to come in the sum of 2.5 million US dollars after the space flight had landed safely and successfully, Your Honor. Emphasis on the fact that the space flight should have landed safely and successfully, to which Solar Dream Incorporation kept to their end of the agreement, being that the space flight landed safely and successfully. However, Your Honor, Ms. Artemis has failed to remit or to pay her final instrumental payment in the sum of 2.5 million US dollars, and this amounts to a breach of her contractual duty to pay that particular amount to Solar Dream after the space flight had landed safely and successfully, Your Honor. Your Honor, it is on these grounds that we submit that Ms. Artemis Ashotia is liable for a breach of contract, and we pray that this honorable court holds the same.
Thank you.
Thank you very much, Your Honor.
Thank you.
Thank you, Your Honor. If Your Honors have no questions for me, I seek leave of the court.
Unless it has.
No, I have none. Thank you. Can we proceed to the junior claimant?
Yes, Your Honor. Can you hear me?
Yes, I can hear you. I can't see you though. Yeah, I
Hello.
can see you now. Yeah, thank you.
Yes. Okay. Shall I proceed now?
Yes, please.
For more clarification, there was a contract that was signed by both Solar Dream and Ms. Astorthia. Solar Dream owed Mr. Astorthia, our client, a service and a duty of care that she already paid for and was assured to receive. To delve deeper, Solar Dream, as a space flight operator, owed our client a duty of care as a passenger to ensure her reasonable safety procedures. Solar Dream breached its duty by allowing her to fly without receiving her PCR test results, and this breach that directly caused her and others to catch the virus on the flight, cutting the retreat short and preventing her from taking the planned yoga activities. On behalf of claimant, respondent is liable in tort to argue the fact that respondent affect the reputation of claimant as an influencer and content creator who promised her followers to have recorded a yoga session in space despite the fact that the trip did not success. However, the non-success of the trip resulted the effect on claimant source of income. So the damages here, medical expenses due to COVID treatment, and the cost of the yoga retreat and any additional expenses caused by its cancellation, depending on the severity of her illness and the impact on her well-being, and a potential compensation for pain and suffering could also be considered. Um, to establish the breach of contract here, a contract existed between Ms. Astorti and Solar Dream. Solar Dream breached a term of that contract. The breach caused her loss. So, Your Honor, under Article 8 of DIFC contract law, the capacity, it gives the freedom to our client to enter into a contract and determine its content. And under the Article 39 of the non-performance of the contract, also it will be applied to our case due to defendant not performing the contract as it shall be. And under Article 14, Your Honor, of law of damages and remedies, it also will be applicable due to loss of claimant of many aspects.
Okay, just a couple of questions I have.
Yes,
So I'll
Your
just
Honor.
ask the main one. One, was your client not aware that PCR test results were awaited? And second, when the variant was widespread and when the tests were taken, did your client not conceal that there were headaches? Be it innocently, thinking that okay, I have a chronic illness, headaches recur. Be it innocently, did your client did conceal? So would that not have an impact on what you're claiming?
Yes, Your Honor. Our client had this chronic headaches for years, and she didn't feel like she have to declare it because it won't affect her fitness to fly, since she's having it from years and she is adapting well with it. And the first question, Your Honor, sorry.
You can proceed. Was your client aware that PCR test results were awaited and the flight is gonna still continue?
I did not mention that in the problem, but yeah.
Council, I have a question regarding the laws of obligation now. Like, how is omitting like this kind of information not misrepresentation under Article 29(5) of the laws of obligation to the DIFC?
Article,
29(5).
yeah.
Yeah, how is this not misrepresentation? Omitting such information, the chronic headaches.
The contract mentions, Your Honor, that she had to disclose any condition, any health condition that will affect her ability to fly.
Okay, thank you. Thank you so
She
much.
didn't mention like the term headaches specifically.
Okay, thank you. Council, proceed.
Okay. Your Honor, and under clause 7 of the agreement, it contains safety protocol obligations. Solid Dream breached through lax COVID screening. And this breach directly impacted her ability to undertake the planned yoga activities she had paid $10 million for. If they have done all procedures and took precautions and informed her that she had a positive PCR test, she would not have aboard the flight and infected other passengers. As per the clause 5.3, which states, and I quote, the passenger undertakes to promptly inform the spaceflight operator if there is any change in their medical condition, or if they become aware of any medical symptoms that may affect their fitness for space travel. This includes any changes that occur between the time of the initial medical evaluation and the scheduled launch date. End quote. She did not encounter any new change in her conditions, and her headaches are not affecting on her fitness to fly since she is having them years ago, and she is well adapted with them. In result, they hold liable to the spread of virus among crew, passengers, and the damage resulted of their action. Um, we have case laws here, Your Honor. Dono versus Stevenson, 1932. It was held that a person owes a duty of care to those closely and directly affected by their actions. Solar Dream here, as a space flight operator, owed her a duty of care as a passenger to ensure her reasonable safety. This likely included proper protocols to screen passengers for infections, diseases that could harm other passengers. Solar Dream breached that duty. They did not take reasonable care to avoid safety issues that may lead to spread of the COVID-19 on board the space, which could reasonably be foreseen, and as a result, it breached the duty of care. And I have another case here, Your Honor. Uh, Haley versus London Electricity Board, 1965. The defendant was held to be in breach of their duty of care. The extent to which the harm was a foreseeable consequence of the defendant's action was indeed a crucial factor when determining how a reasonable person would behave in this circumstances. In consequence, Solar Dream breached this duty by allowing her to fly without receiving her PCR test results. Despite the risk of the Vulcan variant, its protocols were likely inadequate. Adequate. The breach caused her loss. So this breach caused her directly caused her and others to be sick on board the space craft, cutting the retreat short and preventing her from undertaking planned yoga activities, which caused her the loss of the anticipated income through her YouTube channel. Uh, that the defendant action materially contribute
Counsel,
to the
can you
event
please,
that led to her loss. Yes,
or
Your
Counsel,
Honor.
can you please conclude your submissions?
Yes, of course. So here, the clause 5.2 doesn't mention specifically, as I mentioned before, Your Honor, headaches. It requires disclosure of medical condition or symptoms that might affect fitness. Miss Astortia did not feel like her headaches, especially concerning, could be relevant to space travel. She didn't consider her symptoms material enough to disclose, as she is having the chronic headaches for years now, and she is adapting with it fine. And cancellations were because of the defendant's Solar Dream safety and the protocol failures, not because of her disclosure. Um, here, Your Honor, we are seeking damages of $15 million by way of refund and damages for failure of Solar Dream to provide her the service she paid for, and the cancellation of the yoga retreat and her inability to enjoy the activities which she already paid for and she didn't receive any service. And her loss of earning as a YouTuber due to her inability to film a series of space yoga activities, which she had widely advertised and felt keen embarrassment about failing to pursue. Your Honor, can you hear me, Your Honor?
Yes, yes, we can hear you.
Yes, thank you, thank you. Let's move to the rebuttals now. Let's start with the junior defendant.
Thank you very much, Your Honor. Your Honor, it is still the defendant's submission that Ms. Artemis Astrostia is liable for a breach of contract, having in mind that the fifth clause
Definitely.
of the agreement expressly states that every participant,
All the best. A good weekend. I won't. Don't worry about it.
Your Honor,
Yes, please tell me.
okay, thank you very much, Your Honor. Having in mind that the agreement expressly states that Miss Artemis is to declare any medical condition and any symptom of any medical condition. And also, Your Honor, we can juxtapose this with the paragraph 8 of the Moot problem, which states that Miss Artemis was given a medical logbook in order for her to declare and to state every ailment that she suffers from, which is in line with the contractual obligation contained in the fifth clause of the agreement. And also having in mind that the position of the law expressly states by virtue of Article 10 of the DIFC contract of 2004, and also in the laid down case of McDonald and John, that once parties enter into a valid contract, that they are bound by the terms of that agreement. And the provision of this contract states that Ms. Artemis is to declare any symptom of any condition or any ailment that she had suffered from, and it is our strong contention that this headache ought to have been declared in order to prevent any loss or any damage resultant of her failure to declare this medical information. And Your Honor, it is on this grounds that we still vehemently submit that Ms. Artemis is liable for a breach of contract, and we pray that this honorable court holds the same. Thank you very much, Your Honor.
Thank you, counsel. Please, can we just move to the sub rebuttal from the junior claimant?
Yes, Your Honor. So here, Your Honor, uh, can we say the headache were directly linked to any safety incident or flight issues, or um, the reputational damage from cancellation, was it caused by Ms. Astorthia non-disclosure and not from external factors or their own safety failures? They also did not take other passengers and crew lives in consideration, and that is negligent, Your Honor.
Is that all?
Uh, One last thing, Your Honor. Since she was in quarantine for 2 weeks, Your Honor, in the flight operator's place, uh, from where did she get the virus? Isn't that also their responsibility?
Okay. Thank you. Do you have any questions, Aditya?
No, I don't have any questions.
Okay, now none from my side too. Thank you so much to all. You all did a very good job. Uh, we will just be heading to the judges' room to score, and that's it. That would be the end of the session. You guys can have a good day and good luck for the next sessions.
Thank
Thank
you, Your
you.
Honor. Thank you.
Thank you. Thank you. All the best. I would just say that a good job. And yeah, yeah. All the best.
Thank you, Your Honor.
Okay.